Cool, welcome everyone. Just bear with me whilst I do the usual back office stuff here with yeah, we'll tick a few boxes in. Well, that's that bit done. Oh, here we go. Got to mute that for a start. There we go. Um, right, and then if I do that, we're all good to go. Okay, yeah, cool. So let's do it. Hope you guys all had a reasonable week. Let's pin that message as well. Yeah, usual sort of stuff. So please don't share personal data in the live chat. So if you're going to ask a question, basically just put it in the third person. What if someone blah 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 blah, rather than saying I'm in this situation, what should I do? You'll get the same answer, but you don't have to put your data on the internet, which is all good. And it's not legal advice, so we're going to do our best here to be
Oh
helpful
yeah,
and kind of give you some
use
pointers. Oh, is that so you? um, so yeah, just bear with us. And I guess, hey, what Tiff? Um, yeah, I guess just the kind of more succinct the questions can be, the probably the better answers you're going to get, because sometimes it can get a bit confusing. But we've had we'll start with, as always, the questions that have come in through the week that have been anonymized, which makes my life easier. We'll then get into the anonymized questions in the live chat. If there are non-anonymized questions in the live chat, I'll have to delete them, so I apologize for that. And then we'll finish off with the non-anonymized ones from the channel, if that makes sense. So any gossip from you guys? I was hoping Shannon would be here actually because of the changes to Pip, which I'm because she kind of keeps up to speed with DWP stuff. I'm yet to actually know what if the changes have been confirmed, as in if there's any detail yet as to what it's going to mean, other than the fact that it seems there's going to be some pretty significant cuts across the board, it seems. But yeah, I wasn't sure if Labour are still flip-flopping about it a little bit. So yeah, anyway, there'll probably be more stuff on that in future weeks. Let's get the old Word document up and we'll get started. So here we go. Question one is this one here. And again, this is kind of more of an interesting one around someone trying to get some systemic changes in their area. So let's get that numbered as well. There we go. So I made an FOI request asking for the number of people or amount of money spent reconnecting people via bus, train to their local areas. The council has responded, information not held. What can I do? Surely they have to hold this info. So just to give you a bit of background as to what this question is going to be about. So some councils completely illegally, when someone approaches them from a different area, will just give them a bus ticket back to that area. That's definitely not okay. They have to accept the application and proceed on the basis of the facts. But a lot of councils are slightly more clever, and they'll basically have a contract with a local charity who'll do that job for them. So they'll basically arrange the bus tickets or the train tickets or whatever, which isn't technically illegal, but it's still clearly a frustration of what the law is all about. So I guess I have a feeling that the FOI here won't be successful, because I think what's probably going to have happened is the council will give the charity a lump sum for various services, and they essentially won't monitor what the kind of outcomes were, and they'll probably do that deliberately, so they don't have to give this sort of data out if an FOI comes in. So I think that's unfortunately, I think that's probably as far as you're going to be able to take it in terms of if they've built that kind of ambiguity into the way they record stuff. I mean, you think a council, if they're paying a charity to reconnect people, they would have some kind of monitoring for it. But as I say, because it's like legally dubious, I think they probably aren't. Yeah, many councils probably won't. So I think in terms of kind of how you would approach those practices, I think you might have to, I don't know, potentially challenge the charities directly and say, are you complicit in gatekeeping by sending people back to their home areas, and how do you carry out risk assessments? I think I've probably mentioned it before in one of the videos, at least one of the videos, where one of the first cases we had was when someone approached the council having fled from Bedford. The council referred them to a local charity who paid the bus ticket back to Bedford, where they're at risk of abuse. So clearly that's, as I say, that's a frustration of what the law is all about, but it seemed to be pretty standard practice for them. So yeah, anything to add on that one there, guys? Uh, if not, we'll go to this next one. And I have a feeling we might not have the full information to kind of give a full answer here. If someone had been allocated main duty and in priority need because they have a 15-year-old, will they still be in priority need in June if the child is 16 by then? Also, what they what should they be offered? Oh, sorry. Also, should they be offered interim accommodation if they're a week into being offered the main duty? Thanks. So I probably want to actually separate these out into two questions because they do stand alone actually. So if we just do the first one, so the answer to this is quite simply yes. A child is dependent up until their, well, at least their 18th birthday. I think actually technically it can go a bit further than that. But so yeah, just because you hit your 16th birthday, yeah, you're still going to be fine in this situation. But it does kind of raise this issue, and there have been various cases over the years where councils have basically been well, they've not just been criticised, they've been kind of found to have acted unlawfully by unnecessarily delaying decisions until someone turns 18, because obviously same thing with for a single 17-year-old. They may well be automatically in priority need if they've approached and made a homeless application having been through children's services already. But I think there was a case where basically the council just held on making the main decision, the final Section 184 decision, until the 18th birthday had passed, because they were no longer automatically in priority need. And as I say, the council were found to have acted unlawfully. So that kind of thing can matter. But in the case where it's just someone turning from 15 to 16, it's fine. Everything's still the same legally. So again, Karis and Will, feel free to interrupt me and add stuff. How you right, Michael? Um, so, and then the second arm of this question, should they be offered interim accommodation if they're a week into being offered main duty? This is more interesting in the sense that it's going to depend on the situation slightly, because I think there might be situations where actually someone may have elected, as in they've specifically chosen to stay in their private rented tenancy, a short hold tenancy, as long as they possibly can be. Because whilst we often talk on this channel about the fact that councils can't tell you to stay until the bailiffs come, you do have a legal right to continue to occupy your accommodation until the bailiffs do come. And in some situations, you might want to do that because it might be that you would then avoid moving into temporary accommodation, because as in a situation like this, the main duty might be accepted, then you actually might get housed fairly quickly. So the only situation where I think, let me try and explain that again slightly. In most cases, well, certainly, let me go back even further. Interim accommodation should have been offered already at this point, because if you're at the stage where the main duty has already been accepted, that means the council's already taken you through the relief period, which have to have been 56 days. And the relief period is only triggered when the council satisfied you are homeless. So that would generally happen much sooner in the Section 21 eviction process. But as I say, in a situation where someone elected to stay in their property as long as possible, then yeah, I mean, I guess you could technically be in a situation where you're still in your assured short hold tenancy, the main duty's been accepted, but you're still there. The fact that yeah, I mean, I think that basically they should have been offered interim accommodation. In fact, in this case, it's already temporary accommodation, so it's already accommodation under Section 193 rather than Section 188. So I think it's going to depend slightly on what the situation is. I think I actually went back to this person to get clarification of this, but I don't think I got it by the time we started tonight. So, um, Will or Karis, you got anything to add to either of those questions?
No, I think you answered them fully.
Yeah. Okay, cool. So, yeah, so I'm trying to think if there's anything else I can add to question three there, that might kind of also kind of cover other potential situations where this might come up. But yeah, basically, if you're already at that main duty stage, you should have been offered interim accommodation ages ago, which would now be temporary accommodation. So I think if it hasn't been, then there is potential complaint to be had there. It will then depend on the kind of the circumstances where you're in a situation where the landlord might be pursuing court costs and stuff like that. Then you might be in a situation where you can basically complain and potentially get some of that money back or all of that money back if the council basically didn't offer it when they should have. So that's question three. Question four. Uh, I haven't got a clue about the answer to this one. This one came up in the Facebook group, and I haven't got the Scooby. So hopefully Will or Carousel can help us out here. So would anyone have any resources around the legality of additional tenancy clauses following allegations of antisocial behaviour? Seems the local authority applied for a CBO, something order. What's the CBO? Not
Mm.
closure order. Don't know. We'll find out in a minute. But failed as ASB was not proven. So now they're trying to tack restrictions onto the tenancy agreement. Secure tenancy, tenant considered vulnerable. So as I say, I don't have a clue. My gut would be probably not. But as I say, I'm not in any way going to kind of be confident about that. So, anyone got any better idea than me?
Mm. That's sorry. The question is whether somebody that they can introduce new clauses into a tenancy agreement. Yeah.
Yeah, in a situation where the ASB, I'm not, yeah, I'm not sure whether it would matter or not whether the ASB has been proven. But let's say in this case it hasn't been. Can they introduce new tenancy clauses?
It's a criminal behaviour order.
Oh, well done. Yeah.
Okay,
So
but
I think they're
that's
two
failed. That's
quite
so it's,
separate issues, those, aren't they? Because a criminal behavior, I mean, I know that if the question is simply can new tenancy provisions be entered into after the tenancy's been started, I think the answer has to be yes, but it would depend on what the terms the can. I mean, I would have thought local authorities might be wise to have a term in the tenancy that says this tenancy will be subject to the council's standard terms and conditions, which may vary from time to time. And as a matter of contract law, it might, lawyers might argue, oh, that's not valid because you can't vary a contract after it started. Um, but I think in terms of tenancy, because it's not just about contract terms, it's sort of about agreeing to behave in a certain way. But it would be odd if the council, if you were there for 30 years and some new tenancy clause was necessary and it was held that it couldn't apply to you simply because you entered into it years ago. But then to come on to antisocial behaviour, most of that is statutory based, especially criminal. So it wouldn't have anything to do with the terms of the tenancy. Um, so am I missing something?
well, so I don't have any more information on this, but my guess is the fact that they mentioned the tenant's vulnerable. It might be something like they want to put a clause into the tenancy saying, you can't have certain people come and stay, or you can't have more than two visitors at a time, or something like that. I might be totally off the wall on that, but I think that's the way I'm reading that. So the LA is kind of putting some stuff in place that they think is going to basically almost kind of help that person not get themselves into a situation where there's ASB, because it may well be not be them that's actually causing it. It might just be the people that they're sort of leaning on them and potentially like, taking advantage of them, that's doing it. So that's, as I say, that would be a little bit of speculation now. I don't know if that changes the answer at all. Um, but yeah, I mean, I think so. It sounds like they would need to check the original tenancy to see if there is anything within it which would allow additional clauses to be inserted at a later date. Am I right in saying that?
Yeah.
Okay, cool.
Although it's some lawyers listening might be sort of shaking their fists at the camera saying, no, you can't change terms later, but because it's all down to the supremacy of contract. That's a sort of rule of civilized society. But I think that with tenancy agreements, there's probably provision for that. Um, but I don't feel too confident to say much more than that.
I mean, if the tenant was happy with those changes, so if I mean, I guess this gets additionally difficult if the tenant's really suggestible as part of their vulnerability, and the landlord comes in and says, kind of puts pressure on them to accept additional clauses. But let's say there wasn't any of that pressure. Let's say the tenant was like, yeah, do you know what, those clauses would help me out as well by just kind of helping me kind of keep the visitors away or whatever. Does that change anything that way in terms of there being more okay?
You're getting closer to an agreement to vary the tenancy at that point. But arguably, there'd have to be some sort of consideration. So in return for me doing this, I'll agree to you doing that sort of thing. But
Yeah.
it's all a bit. I mean, they could just say we're inviting you to vary the terms of the tenancy, and then if you do that, it doesn't have to be a new contract because it could. But I guess if there was some really controversial, I don't. I mean, this the part of the reason I don't know the answer to this is it doesn't come up in practice very much because it's quite rare that a landlord would include in the tenancy some outrageous new provision, such as, you're not allowed to wear red shoes in the common parts. And if they did try and enforce that, I mean, even if it would be an unreasonable term probably, but something that was sort of so outrageous that they'd probably say, well, no, it wasn't in the agreement anyway. Or in fact, it doesn't have to be outrageous, something really significant, like, I mean, for one thing, for instance, if they said, no music to be played after 10 o'clock. That would presumably, then they could say, well, you never agreed to that and it wasn't in the original tenancy. But then they could do you for nuisance anyway if you were making a lot of noise and people were complaining, and it wouldn't need to be in the tenancy. So I don't think the terms of a tenancy are that central to controlling the behaviour of tenants, if you see what I mean. So it's not, it doesn't
But
come up very much.
also, it
Okay.
says the antisocial behaviour was not proven. So
Yeah.
can they?
I'm going to guess this situation where you've got a whole bunch of professionals in a multi-agency meeting somewhere probably without the tenant at all, and they're all kind of just thinking how can they, they've kind of got some legitimate concerns coming in from neighbours, and they're just trying to work out how they
Yeah.
can kind of set someone up to evict them later or something, given that they haven't been able to prove it this time. But yeah, I'd say, I mean, yeah, that's if that's our best answer, that's fine. But I think that yeah, hopefully that'll be helpful for the person who's asked it. Um, cool. Number five. Why has it gone back to number one? That's weird. Hold on. That's going to annoy me. There we go. Cool. So what if subject is homeless and given priority need and vulnerable, and there is relief duty, but main duty not approved, and housing officer puts intentionality TB despite no fault eviction, section 21, and bailiff's warrant. Housing officer then decides to contact subject's landlord. What happens if, out of spite, the landlord gives false information to housing officer regarding tenant, claiming she is intentionally homeless? What happens to the applicant's social housing application? So, this is a messy one. Okay, what do we definitely know? So basically, okay, this is someone who has been accepted as being in priority needs through vulnerability, and the council's then going for an intentional homeless decision. So at the very least, this will mean that the council will continue to have a short-term duty to house the person under Section 190, but that will only need to be for a few weeks off the main decision, that final Section 184 decision has been made. I think I mean, I guess my pragmatic answer is if the landlord provides what appears to be credible evidence, then the housing officer would be at liberty to accept that evidence if, on the balance of probabilities, it appears to be, correct, basically. So, I think if the landlord's providing plausible information, just go back a step. The fact that it's called a no-fault eviction, you can still be intentionally homeless from a no-fault eviction, which might seem like a bit of a weird one and a little bit grubby, but yeah, basically, essentially, landlords will use the Section 21 process when actually the real reason is the tenant's not been a good tenant for some reason. So, I guess the tenant would be at liberty to challenge it and say, do you know what, this landlord's got a grudge. That doesn't look great either. And there would still potentially be defences against intentional homelessness through things like, the usual sort of stuff: reasonable to continue to occupy, unaffordability, domestic abuse, severe disrepair, severe damp and mold that's causing respiratory issues, things like that. So yeah, the landlord isn't going to have like the full ability to kind of give information that's definitely going to stitch this person up, but I'd say there's probably a fairly good chance that they will get stitched up. So I think all the tenant can do is to provide as much information as possible, which kind of shows what's hopefully what's really going on, and kind of basically pray that the housing officer is actually fair in assessing the evidence, because essentially the housing officer is going to have to weigh up the information received from the landlord versus the information received from the tenant, and there is almost like a default kind of the housing officer would say, well, the tenant's got a reason to lie about this, whereas the landlord doesn't necessarily have a reason to lie. So I think there's a bit of an uphill struggle, to be honest, in terms of trying to fight this one. Obviously, if there's some really kind of like hard evidence, the landlord's definitely telling or giving false information, and that's going to be very handy. But I fear that in this situation, this might be a situation where, yeah, the tenant a tenant would be vulnerable to getting a negative decision actually unfairly. But yeah, that's probably the best answer I can give. Will or Karis, you got anything to add to that at all, or anything else that could be done? Really difficult one, and I'm sure it does happen
Hmm.
where the tenant is genuinely, genuinely isn't at fault. But um,
I suppose you could still challenge it on the basis that you'd say, well, this just isn't true, and then see what the false information was. If the information was the tenant, the applicant didn't pay their rent on time, or because all it has to be is that you lost your accommodation as a result of something. So it doesn't even have to be that serious. If you lost your accommodation, it has to be an unreasonable, hang on, intentional, a deliberate act or omission. I mean, it would have to be something wrong. It couldn't just be a deliberate act of supporting the wrong football team. Although technically that fits within the definition, doesn't it? If the landlord says, I can't stand Leeds United, and you supported them, I'm sorry if I'm being silly, but
No,
you
no,
could say,
it's
well,
interesting.
A,
And
that's not a material thing. And actually, if you had proof of the landlord had some other reason, because it would be odd if the landlord was evicting you for something that you hadn't, for a reason that was then later falsely claimed without there being any evidence of the landlord warning you. And then you could challenge it on the basis that if you say it isn't true and the council say, well, we just choose to believe your landlord rather than you, that's sort of irrational, really, because there's no reason to accept them unless there's something to corroborate it. So I think it'd be worth having a go that they had. And you could, if you were challenging it, you could if you were a solicitor challenging it, you could always write to the landlord and say, I understand the person did this and that. Can you tell us a bit more? And if it was false, they probably wouldn't respond, or they might respond and give it information which sort of helped you prove it wasn't true. So it was worth having a go at challenging it. And again, you might be able to show that there were other reasons anyway, because if the landlord, if there's a trail saying I'm getting you out because sorry, I want the property back, and then at the end of it they tell the council, oh, it was because they sort of were a nuisance. You say, well, I may have been a nuisance, but he wanted the property back. So it doesn't matter that I did something intentional that would have otherwise been intentional. So it's worth fighting it.
I think I'm sure there's
Also,
stuff in the. Oh, sorry, Karis.
all right, I was going to say you can request your like information, so it might show up, although it'll be redacted. A bulk of what they're saying should be in there.
Yeah,
So you can ask the council for the information they have on you, on your case. The SARS request. So you'll be looking at putting in a subject access request to your local authority that's
yeah,
housing you. And it should
I'm
give you that information.
I'm pretty sure that it can't be redacted on this case. I think they'd have to put the information to you fairly, and I
Yeah.
think also there's stuff in the kind of case law which says that the council would have to give a reason for departing from the tenant's kind of account. So there needs to be something. You can't just be, oh, I believe the landlord rather than the tenant. There needs to be kind of a reason for that, as in like a logical reason for that. And also the kind of general thing around intentional homelessness is the benefit of the doubt goes to the tenant. So I think that, I mean, I think it's not a situation obviously that you want to be in, but I think there would be, yeah, as Will says, it's definitely worth challenging it for a number of reasons. And I mean, I'm just trying to think, as always with intentional homelessness, there's two really good paragraphs, well, there's several paragraphs in the code of guidance which are great, but particularly 9.7 and 9.17. Because essentially what 9.7 is saying is that all of these three criteria have to apply for the person to be intentionally homeless. So it's not just deliberately doing or failing to do something which means you become homeless. They also, crucially, the third thing says that the accommodation must have been reasonable to continue to occupy. So if it wasn't affordable and then that would be reason for it not being reasonable to continue to occupy. So you can't be intentionally homeless. And then equally with 10.17, I just went way past it. Sorry, 9.17. Hold on, bear with me. That was a bit clumsy. No, come on. It's not allowing me to scroll to the next one for some reason. Oh gosh. Getting there. There we go. So here we go. So there's also these potential reasons why the action should not be considered deliberate. So where you've got like, kind of non-payment of rent that's come from some sort of financial issue, where you've got mental health issues, substance misuse issues, that sort of thing, or whether you're basically under duress. So it's probably worth reading this paragraph as well, just to see if there's anything that might apply. But other than that, yeah, I think it's a difficult one, but I think it's certainly possible to successfully challenge. Cool. So, oh, wrong button. Gosh. So next question here. So there's two questions that came along. They're actually quite similar. So I'm going to just kind of broach them probably together, even though one of them's not anonymized. So sorry for the pedants out there that's going to do this. So because they're both about someone with autism, and I think both have got ADHD as well. So let's just do this one first. So someone is combined autistic and has ADHD, suffering with mixed anxiety, depression, and IBS, which is a kind of a lower intestinal issue. Can't remember what it stands for. Irritable bowel syndrome. Have been placed in temporary accommodation where they're sharing a washing machine with heavy drug users, making the person sick and unable to wash their clothes. There's also no doorbell and no way to set up internet in the accommodation. The sensory overload is too much for the person and has complained several times, currently reassessing suitability for accommodation. I think that was in the council's currently reassessing suitability for accommodation. They've now received a complaint about noise and banging and loud music at unsociable hours, but it's unfair as the music is alarms in the morning and the noise is because they have no kitchen set up, so having to cook off the stove on the floor, which is making noise from the people below them. They appealed the complaint, but the council ignored it and said it will stand despite the person being unfairly blamed for bad behaviour simply by doing the things their needs require, such as cooking and setting alarms for routine. What could be done in the situation? So I guess, again, we've got a question here with kind of two bits to it. The first one is whether the current accommodation is unsuitable. And secondly, what do you do when you have a complaint upheld against you for nuisance type stuff, like which isn't, again, you have some accommodation is the walls are so thin and the flooring is so thin or whatever that it's actually very difficult to kind of be quiet. But in terms of the suitability thing, so clearly this person has a disability. These things, well, almost, they're not automatic, but almost certainly this person has a disability due to the combination of physical and mental health issues they've got. The fact the council is currently reassessing suitability, so that might be that they're kind of either currently obtaining additional medical evidence, or they might be they're putting evidence to someone like, or how Now Medical or something like that, independent medical advisors. So that needs to be done fairly quickly, but I don't know if there's a time scale in it necessarily. I guess what the person can be doing here is getting as much information as possible from supporting professionals to basically demonstrate the person, these issues are real, they actually matter to the person, and it's not just them being awkward. I think in terms of internet setup, I'm not quite sure how, I don't know, I think that's probably a little bit weaker. But I think where you kind of, where the person just doesn't feel able to it's just being overloaded by not having that kind of privacy, not having that kind of quietness or whatever. I think, no, those are things are probably more likely to stand up. So that's my answer to the first bit. Will or Karis, you want to add anything to that bit before we get into the next one?
Sorry, your answer to the first bit is you might be able to challenge suitability if you can show.
Yeah, just get additional medical evidence, basically.
Yeah.
Yeah.
Yeah, I mean, one thing I would add is it's always difficult to complain about drug users, even though it's almost anybody involved in this area knows that sort of temporary accommodation, hostels and hotels and things, like much of London, there's a lot of drug use. But if you raise it, you'll get somebody adding insult to injury saying, we have no reports of drug use and all this sort of stuff. You should go to the police if you're worried about this. But the thing is, it could be just that anybody, if you've got sensory overload, it may be that anybody just walking around talking is going to upset you. So try and avoid using the reference to drug users because it gives them an excuse to sort of play that card. So I haven't got much to add to that. I just think if you can get the evidence to show that you need, basically what this person's saying is they need self-contained quiet accommodation. Yeah. So if you're suffering from post-traumatic stress disorder or a combination of those sorts of things, then it should be possible to get a letter from a doctor or somebody that's treating you saying, that they need somewhere where they're not triggered.
Yeah. Cool. I'm just Googling something quickly that just ties in with this. Yeah, cool. Okay. And then so second bit, in one sense, I guess it's probably worth saying that there are two separate issues, but I think housing officers will have a tendency to probably be difficult about the first bit of it because the person's kind of deemed to be a nuisance in the second part of it. So in one sense, if you had an upheld complaint against you, that doesn't change the fact the accommodation is or isn't suitable for you. So that assessment still needs to happen, and that's basically self-contained anyway, as an argument. I think yeah, it's really difficult. As I say, I've known temporary accommodation, which is really good quality. I've known temporary accommodation, which is terrible, and you've got a situation where basically very little kind of noise will result in complaints from neighbours, and the council will just basically uphold it. I mean, it doesn't seem like that's very fair, because really to kind of make a noise complaint, if your alarm's going off at 6:30 in the morning or something, and it's just a short alarm which you're then turning off, that's clearly, although it might be waking up a neighbour, that's not really unreasonable. I can't remember what the rules are on kind of making noise, but I'm pretty sure well, yeah, certainly kind of workmen and stuff. I think they can make noise between 7 a.m. and 10 p.m. without even having to kind of, sort of shrug, kind of, mention it really. So, yeah, I don't know. Yeah, I would focus on the first bit basically, and just basically focus on providing evidence or making an argument that's unsuitable, with the hope that you're going to get moved, and hopefully the second thing will become immaterial anyway. So that's, I guess, but it's kind of the reality of having to deal with councils. This is very much the nitty gritty, which I'm not sure how much the law actually makes much difference to, because it's just basically a lot of it's just the council's discretion, and you can't really challenge that. If they have a complaint which seems plausible or something, then yeah, I'm not sure what you can really get changed in that situation. I'm just trying to think. I'm just looking at the second question here. Actually, I might save it till later, because although it does mention autism and ADHD, it's actually quite a different question. So in which case, we'll go to the live chat and start getting through the questions here. So where are we up to? Here we go. So, hey, what cheese face? Tiff's just saying about the PIP stuff. So yeah, I mean, I think we'll certainly be kind of covering it at some point in future live streams in terms of what we actually find out. Tiff's just saying that some UC claimants got less money when moved, but they won court cases. I think it was deemed unfair or something. I think these new things they're moving forward with. I think what does seem to be more certain is that it's going to affect younger people more than older people. That's the impression I got from what I read, but I don't know more than that at this point. So, oh, here we go. Verification of rough sleepers, our favourite. So this question here. Friend is verified in writing by council rough sleeper team, but then council said they don't believe she's homeless due to friend being there at time and packing up tent after verified. Is this unlawful? So I guess it's important to say that the verification of rough sleepers process is not a legal thing anyway. It's not legislated for. There aren't really rules about it. But what there definitely are rules about is when anyone approaches any department of a local housing authority and asks them for help with housing and gives them reasons to believe that they might be homeless, then there's a homeless application been made. So the whole idea of sending people away to rough sleep to be verified is legally problematic already. And again, just to make the point, rough sleeping is just one, is almost kind of like an insignificant form of homelessness in the kind of numbers game, because there's only a few thousand people rough sleeping, but there's a couple of million people or whatever who may well legally be homeless. So the fact that this person may not be rough sleeping, it doesn't actually change the fact they can make a homeless application, and they should therefore be kind of treated as such. The verification of rough sleeper processes it varies from area to area. In some areas, it does mean you get better kind of package of support, although I'm not quite sure I necessarily believe that. That's what they say that you get. So it can make a difference in terms of maybe some additional support you might get. But as a homeless person, whether you're rough sleeping, whether you're sofa surfing, whether you're whatever, whether you're legally evicted or whatever it might be, the council has to accept a homeless application and proceed with it. So yeah, it may well be unlawful. What this person wants to focus on is just making a homeless application. So if you go on this channel and look at the video, the best way to make a homeless application, I would just suggest following the steps in that video and just kind of get an idea of what you need to do to actually make sure the application's been triggered properly. So yeah, I mean, I think that they may be in their rights as a rough sleeper team to say, yeah, we don't think you're rough sleeping because you packed your tent up after you got verified. But that's not the question when it comes to homelessness. You're homeless, then you're homeless. And actually, if there's reasonably that you might be homeless, the application has to be accepted, and the council then need to make sufficient inquiries to establish that you're not in fact homeless. So that would be a case of them finding out that you in fact live in a property and you pay rent there or something, and they would then be able to say, yeah, you're not homeless. But until they've made those inquiries and issued a written decision, that's all. Yeah, that's kind of not the way the process works in terms of this verification stuff. Kara, so will you add anything to that one?
No, I agree with what you said.
Cool, all good. Yep, cool. So question 8. What if you're in temporary accommodation with priority need and now main duty? What if the council want to move them still within the borough but out of area, which makes getting to hospital hard? So within the borough but out of area. So I guess we're talking about a kind of a medium, a medium distance kind of move. I'm just thinking some boroughs, Central Beds is a good example. It probably takes 2 hours to get from one end to the other via public transport. So although you might only be like sort of 20 miles away or 30 miles away, it can still actually be quite significant. I guess the question is going to depend here on what do you actually need to go to hospital for, or is there a closer hospital somewhere else? So if it is a very unique medical issue you've got, and there's only one hospital in the world that kind of deals with that, or one hospital in proximity that does it, then you might be able to kind of advance an argument. I don't know if there's anything kind of whereas there's kind of time limits on travel to school and stuff like that. I don't think there's anything around kind of what it actually means to be reasonable to kind of travel to a hospital. I guess another thing is how often you need to go. Do you get PIP? Does can the PIP be used for transport? That sort of thing. So I would say it's probably a relatively weak argument unless there's very, very specific things about the hospital and about the medical condition. I mean, I guess if the part of the medical issue is the fact that the person's a wheelchair user or something like that, that's obviously going to have a bearing as well. But I think it's probably a fairly weak argument unless there's those specifics. I've only ever come across one case ever that was kind of there was a kind of legitimate need to attend a specific hospital because there was only like one hospital in the country that dealt with this condition, which was where the intestines are outside the body, and they needed to be in that location. And I guess there might be arguments around someone like Great Ormond Street Hospital for kids because again it's very specialist. But I think it's going to be difficult. I think you advance your best argument here and explain that that maybe your argument is it cost X amount on the bus. I don't have that money. I need to go there 5 times a week. Therefore, it's a problem for me. But I think other than that, you're going to struggle to kind of get anywhere with that. So, right, next question, which seems to be, I'm not sure if it's a second part of a different question or not here, but let's have a look. So, solicitor made representations and counsel is asking for the extension of the review of section 184. The person has strong medical evidence. Should a person agree or disagree with the extension? Will or Karis might be a better place to answer this than I am, but I would say if the evidence is strong, then and you're willing to go to court about it, then I'd say don't agree to the extension. But that's just my opinion. Will or Karis, you got anything? How would you kind of deal with this? Would you be more patient than me?
Yeah, always agree to the extension. That sounds really bad, but you're giving them time to make, if the other person, if they want to make inquiries, then giving them an extension will give them time to do that. And also if you want an extension on your side, you've given them an extension their side. So it works both ways. Always agree extension. I don't know, Will?
Yeah, I totally agree. If you're in temporary accommodation and there isn't some pressing need for a decision to be made for your, immediate welfare, then you really should agree an extension, because if the alternative is to go and issue an appeal on the basis that they've failed to carry out a review, in which case the legal aid agency, if they're paying for it, would almost certainly, if you told them they'd asked for an extension and you said no, we're not going to go for it, they would say we're not going to fund you to go and have a fight now, because if they only want 2 weeks and they're going to make a decision in 2 weeks, then it could be that all of the money would have been wasted in issuing the appeal, because they might have made a positive decision then, and even if they didn't, you could appeal it later on. So I think the solicitor would probably tell the person, I can't, it's not just some sort of game where I can say, ha ha, got you, sort of, you're out of time, we're going to go for it, because the judge and the legal aid agency would both be very critical of that. Well, I mean, the legal aid agency would just refuse legal aid on that. I got a legal aid certificate refused the other day, for instance, because I'd said that the council were failing to process a homelessness application, and the response they'd sent me was sort of, "Oh, all right, we'll do one," but they weren't doing very much about it. So I thought, well, I'll give it a go. But I think they were right to say, no, you're jumping the gun here. And I can always go for another certificate later on when they're still not doing it. So, yep, extension, and of course, if this is the first, if this is extension number 5, and there's no good reason given for it, then you might be entitled to refuse it. But if as it sounds, it's just number 1, you definitely shouldn't refuse it.
Cool. Okay. And if this person's not in temporary accommodation at the moment, would that kind of change that at all? Would it just be a case of asking for the person to be accommodated whilst it happens? I mean, does that change the kind of balance at all here?
Yeah, I think so. If you'd said to them, yeah, I'm street homeless, and I think you should make a decision in my favour, and they say, well, we're not going to do that, but when we want some more time, you should say no, this is urgent. Although then again, if they refuse to give you temporary accommodation and they haven't completed a review, you'd be better off going for a judicial review of the failure to give you accommodation pending the outcome of the review, rather than refusing to allow them more time to complete the review, if that makes sense. So, yeah, it's just you've got to be seen to be acting in a fair way, and refusing an extension is not fair. Just like if you asked them for more time to put in representations and they said no, the court would be quite critical.
Okay, cool. Okay, cool, nice one. Next question. Let me just check I've missed one here again. So, question 10. So this is another kind of like difficult one, really. So, would a person with complex PTSD be moved quicker if they were living in a shared house, which is making the person conditions a lot worse? So, there is an argument, albeit a rather difficult argument to make, that if you have a disability, which complex PTSD could well lead to someone having, and living somewhere, there's really strong evidence that living somewhere is making it much, much worse, then there's an argument there that you're legally homeless right now. But as I say, as arguments go, that's a tough one to make. You need really, really kind of clear-cut evidence, ideally from a psychiatrist, which is kind of giving that sort of level of detail, which I would say is quite difficult to get. We've talked before about how difficult it can be to get medical letters anyway. So, what it could also do potentially, and I have a feeling this is a question about Bournemouth, so I think I know the background here, which this wouldn't help, is that if you're in accommodation like that, then although you might not be legally homeless, you might be able to get some points on the housing register. Now, as I say, I think this question relates to someone who doesn't have local connection under Part 6 under the housing register process, rather than, whereas they probably do have local connection under Part 7. So, I don't know that there's really. I'm not quite sure what your prospects are of challenging it. The thing I was googling earlier actually was, if this person's getting PIP for the complex PTSD, it does mean that they are eligible for a one-bed place, a one-bed accommodation. Now, I don't know if that doesn't mean you're going to get that. It just means that it's an option. So if the person was able to go looking for self-contained accommodation, then if they were getting PIP, then it might be that they are actually able to kind of get a local housing allowance for a one-bed place rather than shared accommodation. I don't know if that bit there's relevant to this situation. I'm not sure how old this person is, but yeah, that kind of, again, for those who are under 35, ordinarily you're only eligible for the shared accommodation rate from the local housing allowance rather than the one bed rate, except where certain exemptions apply, one of which being where you're getting PIP. So I don't know I can be any more positive than that. As I say, there's an argument to make. I guess technically speaking, it's a shot to nothing. You don't lose anything by making a homes application by literally saying, yes, I have accommodation, but my complex PTSD is being made much worse by being here there, and here's the evidence from my psychiatrist or something. Then I think, unless you can kind of get to that level, you're probably not yeah, it's probably not going to result in anything useful. So yeah, sorry not to be more positive about this. So I think this is a multi-part coming up here. Just by the way, guys, I've just put a little note on the live chat just saying no more questions in the live chat for tonight. So any further questions after that point, we'll roll over, or if you bring again to the next live stream. So let's check here. So I think there's more to this one. Yeah, I think this all relates to the same thing here. So yeah, so what if alternative TA was offered under main duty? So I think this relates, by the way, to the kind of the hospital question we had earlier about travelling to hospital. What if alternative TA offered under main duty is rejected, but council say suitable? How can you challenge suitability and stop council from moving from current TA? Client has disability, rejected alternative TA due to unsuitable and not wanting to move. Instead of taking alternative TA, client's family paid for temporary hotel. Can council end agreement, and how can you challenge enter the duty? Okay, so yeah, on this case, what we're always going to say is it's really unwise. You're basically taking a big risk to refuse an offer of accommodation, unless it is literally like, you're a wheelchair user and it's up a 3 flights of stairs or something. It's obviously just not even possible to get into it. So I would say, again, you can argue, you can basically, would it be under section 202? You basically ask for a review of the suitability of the accommodation, but unless you've got like a very solid evidence, or solid reason for rejecting it, then it's likely the council will just basically uphold their kind of decision that it was suitable, and you basically refuse to move into it. You are then able to make a fresh homeless application, but it's entirely possible that you'll be found intentionally homeless, depending on the circumstances. So yeah, it's a real difficult one for someone who's kind of in this situation, because obviously, I mean, unless you can go back to the council and say, no, we will accept that offer of accommodation after all, we just weren't quite sure of it. I think it's very difficult to kind of move out of it. It's gonna basically come down to the nature of the disability, the nature of the reason that it's unsuitable, and kind of just looking at how that kind of works. So it's a real difficult situation to be in, unfortunately. Will or Karis, do you want anything to that one?
Not really. I mean, if you refuse an offer of accommodation, that's problem number one. The council may say, well, we're treating our duties towards you as discharged. But the fact that you may be able to get temporary accommodation alternatively through a hotel wouldn't necessarily make it worse. You just say, well, my family were helping me out temporarily. The key thing is whether the council maintain that they've offered you something and you unreasonably refused it. Which we always say don't do. Accept it and request a review.
Yeah. So I think, I mean, this doesn't help the person at all. I think it's just a warning to anyone out there: when you're getting offers of accommodation, however difficult it is to move in, it really is in your interest to move in if it's physically possible to do so, and then kind of worry about challenging, because you can still ask for a review of the suitability if you move into it and still say, this isn't suitable. But you really do run a big risk of as Will says, like the council basically discharging their duty. And if you were to make a subsequent application, you would be found intentionally homeless potentially. So yeah, it's really not to be advisable to be turning down offers of accommodation, any offers really. So yeah, sorry, that's not very positive at all either. We've got a bit of a miserable set of questions tonight. That's not your fault, but just yeah, kind of it's just the way the law works, I guess. Question 12: what if temporary accommodation has a mouse? Person is on band C. Can't they request band A, as this band is for management transfer? So it depends on the level of the mouse infestation. I think, yeah, I don't see you get moved up to band A for that reason. I think the kind of initial response would be to get pest control in. I mean, I think the landlord, as in the council potentially, or whoever, does have responsibility that you kind of live free of having infestations of pests. But I don't know any housing allocation scheme in the country that would move you up. Management transfer tends to be for very specific kind of situations, things like domestic abuse, stuff like that. I've not heard of it being useful when there's pests. And as I say, plan A would be to get pest control in there and see if they can get rid of the mice. and then if they can't, I don't know. I don't know how there are certainly some LGSO cases I've read where the infestation was so bad that they had to be moved somewhere else. So as I say, it does depend on kind of how bad it is. But a single mouse, yeah, it's not that. Yeah, they're going to be looking at kind of getting rid of the mouse first before they look at anything else. And I don't think it would then affect your banding anyway. That's my reading of it. Correct me if I'm wrong on that, Chaos or Will.
And I've even heard them say, "Oh, well, you're gonna get mice here."
Yeah,
They're like, "Oh, it's normal."
yeah, which is that's definitely not legitimate. I mean, I'm trying to think. There was one in Basildon. No, I can't remember which one it was. There was an LGSO one I read recently where it might have been the Herefordshire one actually, where one of the issues was this kind of infestation. It might have been rats or mice. I can't remember, but they kind of there's some interesting stuff within that. So if you go and look on the YouTube channel and you look at one of the LGSO Herefordshire one, I think they got like £13,000 or something. I think if you look at the title, it's like 13k compensation. Have a look at that because part of the issue, I think there was an infestation of mice or rats or something. So yeah, yeah, that's yeah. I don't think it's gonna bump up anyone's banding on that for that reason. So I'm not sure if I missed part of the conversation there, but I think there's a few comments there that aren't questions, which is all good, but I don't know what the context is. So I think we've had iterations of this question before. If someone is registered for housing in rented but low priority, but has mum now living with them who is elderly, dementia, and depression, is it better to start a new application under mum's name? Uh, no, I don't think so, because I don't see why. Because when you might want to just basically get rebanded because if you're at low priority and your household circumstances change, then you can just basically do a change of circumstances form or whatever they call it in your local council. There's no, I don't, when councils like assess the needs of a family, it doesn't really matter who, I can't think of a situation where it really matters what the lead, who the lead applicant is. I think if you've got a situation where you've got someone in the household who has dementia and depression and so on, then they would still get the same banding, whether they're the lead applicant or whether they're just part of the household. That's my reading of it. There are some weird and wacky situations in the homeless application process where they wouldn't be true, but where we're talking about essentially kind of the needs of the family, then I don't see how that's going to improve someone's banding. Again, Carrison will correct me if I'm wrong on that one.
I think you're right.
Cool, yeah, and just so there's a real quick question there. So, does Band A mean member of council management can allocate properties to anyone they choose, to whom they choose? Not usually. You have to check the individual policy. There are some policies that will have an additional band. So, for example, confusingly in Bedford, there's Band E, which stands for emergency, and that would be kind of where they would just do management transfers. But generally speaking, Band A, you're part, you're in the process as anyone else is, and you have to wait until you kind of you win a bid or whatever. So, right. If a council place you in interim temporary accommodation, however, due to lack of space, none of the furniture fits. Oh, hold on. To the point the boiler room is filled and they can't walk around. Can this be used to request a bigger place? So there might be an argument to say that the council should store someone's belongings if in a situation where you literally can't fit in. I think that I mean, I don't know quite what the law would be around, safety and stuff, but I guess you need to be able to walk around your flat. So if you literally can't get into important parts of the flat, then that's obviously going to be a problem and the accommodation is not suitable. As I say, it wouldn't necessarily mean they'd move you. They might just go and store some of your belongings, which they can effectively charge you for. So I think that would be you can always request a bigger place, and kind of it's not a silly argument, but I think a lot of councils would basically kind of not be terribly forthcoming to help you out. As I say, if you really push them, they might agree to protect you or store your furniture, but they would then charge you, so you'd have to repay that at an affordable rate over a long period of time, basically. Okay, here's a question I can probably give a more positive answer, or certainly a more kind of clear-cut answer, which is nice. So, what's the difference between main duty and relief duty, and what does it mean when your relief duty ends and they place you in main duty? What are the pros and cons for both? So, This is a really this really sounds scary, because what often people get is they'll get a letter which says we're ending the relief duty, and then you might then get a letter which says, oh yeah, by the way, we accept the main duty. Why they don't put it in the same letter, I don't know. Why they don't explain what it means, I don't know. But basically, the main duty is better in every single regard than the relief duty. So if you're owed the main duty, there is no con compared to a relief duty for that. It is very good. It means the council is accepting you're in priority need, you're not intentionally homeless. It's going to give you a higher banding on the housing register. It's going to lead to a better quality of discharge of duty. So, for example, if you're going to get a final accommodation offer under Part C, under the relief duty, it will only need to be a 6-month assured short hold tenancy, whereas a discharge under the main duty would need to be at least 12 months assured short hold tenancy. And I think there's additional kind of checks and balances around quality of accommodation for that. So, although it seems scary, you'll get a letter which says, we kind of the 56-day period has come to an end. When you're getting a kind of a simultaneous letter saying, yeah, we accept the main duty, that is all good. So that is a good situation to be in. There's nothing to kind of worry about there. In every way, although it doesn't kind of magically make you housed, in every way, it's going to increase the chance of you getting decent quality accommodation. So yeah, that's all the questions in the live chat. As I say, there are some more questions afterwards, but I put that time limit in there. So any other questions that have not been answered here, I would suggest you roll it over to the next week. So either put it as a question onto any video on this channel, or yeah, basically come back in next week's live stream and just ask it at the beginning of the session. If you find this stuff useful, by the way, I guess to do the YouTube stuff, please feel free to give it a like, give it a share, or whatever. And if you're not subscribed, you will get notifications of new videos if you do. But then to finish off, there's a couple more questions that came in through the week. This one's a rather long one. I probably should have summarized it slightly before we got into it, but let's have a look. So, question 16. So this person has autism, ADHD, severe depression, and severe anxiety. However, I'm being told I'm no more vulnerable than an ordinary person, and they say I have no priority needs. So that is, by the way, that's absolutely normal. In the sense that lots of councils, no matter how vulnerable you are, they'll list your conditions and then say, we have carefully concluded that you're not any more vulnerable than an ordinary person. That's just the way the kind of the wording of the law is. It's an unlawful, it's a perverse decision probably, but it's not. It's in one sense, it's not something to be surprised about. That's just how councils work. Also, the X-rays on my spine and of narrow discs and degenerative change. My guess is that's going to be affected by sleeping rough on the streets or something. Despite all medical evidence given that they're arguing I'm saying I'm not vulnerable in terms of housing. However, my doctor has written a letter saying I am vulnerable. So on that point, the actual letter itself that says I think my patient is vulnerable doesn't actually help. The doctor needs to give basically a prognosis of what happens to that person if they were homeless, if they were street homeless in particular. So, for example, my patient has narrow discs, and if they were sleeping on a park bench, they are likely to get much worse. That would be the sort of thing that would be very strong evidence the person's in priority need. I'm under mental health services and have mental health coach. I see weekly and I was referred due to suicidal ideation, self-harm, suicide attempts. But yeah, I'm being told I'm not vulnerable and have no priority needs. I think the short answer to this question is probably get in touch with Vogo solicitors. I'm looking at Karis and Will now to see if you guys have capacity. Yep, we've got some nods. Will, could you do me a favor and just send me the link to that online form again?
Yeah, sure.
Because I think, I mean, this basically sounds to me like a case where there is overwhelming evidence this person is in priority needs, and it's just a perverse council officer being just abusing their power, basically. So yeah, I mean, there's loads. I mean, yeah, I'm not sure if there's. We don't really need to go much further. Oh yeah, the last bit there. The letter, however, still said I have no disability and no protected characteristics. Again, it's just the council officer using the template letter. It's nonsense, but they do it, and it's going to be easiest to challenge it by having a solicitor on your side. So I will just get that copy link and see if this fits in the chat. So yeah, I've just put it into the live chat there now, and I'll just put it onto here as well, just so I don't forget. And then, so final question for this week is this one here. So just bear with me a sec. Right, I'm very slightly confused by this question, but let's see if we can unpick it. So if a person is currently appealing Section 184 with the help of a solicitor, can a late rent payment or missed rent payment have any impact on the council decision? So I then went back to him and said, what's the council decision? I think they said it's it's a not homeless decision, basically. So the decision that is being challenged is that the person is homeless as current accommodation is not reasonable for that person to stay in because of health problems. They will then go on to look at eligibility, priority need, and intentional homelessness. And it would then depend on the reason for the late payment or the missed payment, because again, as I kind of flashed up on the screen earlier, 9.7 of the Code of Guidance and 9.17 would both potentially come to the rescue here a little bit, because if the reason for you not paying the rent that month was because of financial difficulties that are outside of your control, or just because your rent was unaffordable, then those can't be used against you with intentional homelessness. So in that sense, no, it doesn't necessarily cause you any trouble depending on the circumstances. I guess probably the thing to say here is that you should try and repay, try and sort that thing out so it doesn't come into it later on. But I don't know that it's going to make. I mean, I guess as I say, it could technically come into. In fact, no, do you know what? It can't even do that, because if essentially your argument is that your current accommodation is not reasonable to continue to occupy, then actually missed rent it wouldn't make any difference anyway if you haven't paid the rent, because it's already unreasonable. So ignore what I've said. That let me just kind of explain what I mean by that by just going to the Code of Guidance briefly, just to kind of draw that out. So sorry, just kind of thinking on my feet a little bit here. So we go up to 9.7. So again, just as I said earlier, all of these three criteria have to apply to be intentionally homeless. So even if you deliberately didn't pay the rent or missed a rent payment and there was no good reason for it, but you've successfully shown that it was not reasonable to continue to occupy the accommodation, then you can't be found intentionally homeless. So in that sense, it can't matter. I guess it could technically matter if you then get main duty accepted on the housing register, but a housing association refuses to consider you because you've got rent arrears. Again, it could come back like that, I guess. But I'd say that's probably not your main problem right now. So I think yeah, I think focus on kind of getting that decision overturned, showed it was unreasonable to continue to occupy. You may well still have the same. You still have to make an argument about being in priority need, because that's, again, that kind of comes later as well. But I don't think, certainly if I'm thinking correctly out loud, that it's going to mean that you're going to be found intentionally homeless. So yeah, you are, Stella. Anything to add on any of that, guys? If not, we can call it a day. Will, are we here for yours on Monday? You
Yes,
around?
all being well, we should be going on Monday at 7:30. So everyone's welcome.
Cool.
Just type William Flack channel in YouTube and it'll come up.
Yeah, cool. I think I will be there. So
Great.
yeah, cool. Cheers, guys. We will see you soon. Hopefully this evening's been useful. It feels like the questions, a lot of them were kind of rather rather miserable answers, really. But yeah, I guess that's the nature of homelessness. So yeah, but hopefully there's been some useful stuff in between it all.